The Honorable Supreme Court of the State of Iowa is now in session.
Well, this is like night court. Thank you for joining us. We have 3 cases to be submitted this evening. The case of Stoughton versus State of Iowa and the case of Bright versus the State of Iowa are both submitted without oral argument. We're going to hear an oral argument on the case of Miller and Duffner versus State of Iowa. It appears the parties are ready. Ms. Lorenzen, you may begin.
Thank you, for counsel. Fix that there. The facts and the procedural background in this case have been well briefed by both the appellants and the appellee. So unless the court has any specific questions regarding the factual background or the procedural background, I will set aside any long recitation of the facts. The crux of the issue at hand tonight is whether Iowa's Fraud in Assisted Reproduction Act, or FARA, should be applied retrospectively. The appellants in this case, Bert Miller and his sister Nancy Duffner, brought suit under FARA, alleging that in the 1950s, their parents, Bert and Donna Miller, received fertility services from Dr. John Randall at the University of Iowa, who was the head of OB-GYN at the time. Unbeknownst to them, and discovered many years after both Donna and Bert Jr. had passed away, the brother and sister submitted a DNA sample to Ancestry.com. They were looking to build their family tree. It was at that time they discovered for the first time that Dr. John Randall was in fact their biological father. Not the dad that they grew up with, but the physician who had assisted their parents with their fertility issues in the 1950s. What's interesting about the time frame of their discovery is in and around 2016, cases began to appear not only in North America, but in Europe and around the world, because these direct-to-consumer DNA tests became very popular. There were multiple websites, Ancestry.com, 23andMe, and individuals looking to understand or build their family tree would submit DNA samples, get back information about potential relatives. Well, what happened when that began to occur in and around 2016 is they discovered a plethora of these cases across the country and around the world where, unbeknownst to patients of fertility doctors, their children were actually the offspring of the fertility doctors. There are numerous cases cited in Appellants materials to include Dr. Donald Klein, a physician in Indianapolis, Norman Barwin, who was a fertility specialist in Ottawa, Canada, and Dr. Gerald Mortimer, who was in Idaho Falls. What came from that was a legal movement of sorts. These provinces discovered that something that seemed common sense or obvious, there was no real remedy for the victims of these acts. And states began to enact legislation much like FARA. Consider, if you will, in Iowa, the medical malpractice statute here provides 2 years from the date of discovery, essentially, which under Iowa law is the date that the plaintiff knew or should have known of their injury. And
you talked about no real remedy. You know, in a sense, you have this fortuitous situation where the doctor in question worked at the University of Iowa and therefore was an employee of the state. Would you agree that in the ordinary course of events, if this had been a fertility specialist who had a private practice, that doctor would be long since deceased, their estate would be long since closed, and there would be no remedy, even if the statute were retroactive?
I think that's an interesting proposition. I mean, in this case, Dr. Randall is deceased, as the court's aware. I think the fact that, you know, part of the issue, Justice Mansfield, is that at least in Iowa, Iowa, the University of Iowa is actually started the artificial insemination process here in the state. They were the first of its kind. They provide the vast majority of services. There are private clinics now. So in and around the time when these events were occurring, remember this was in the 1950s, and many of these events occurred in the 70s, 80s, and 90s, the vast majority of these services were being provided through institutions like the University of Iowa. It's only a more recent phenomenon that you have these private clinics. And so that is part of our argument as to why we believe the statute should be applied retrospectively.
Remedies, I know we've got, of course, attorney's fees and some fines or some values of money, but I also want to talk about the criminal aspect of 709.4A. Isn't it possible, because there's technically civil remedies and there's also some criminal aspects, isn't it possible that one could be retroactive, one could be prospective only? And have you ever known another statute to be dealt with that way?
It would be unusual, Your Honor. I think that, when you look at the civil remedy, obviously that we would argue that that should be applied retrospectively. The criminal remedy would then run into potential constitutional issues. But
That the criminal aspect, you can't go back in time on that?
I think that's correct, Your Honor. I think that that runs afoul of ex post facto.
Questioning is almost like to treat it as a hybrid. Part of the statute would be retroactive, part of it would be for the future. Is that correct?
Your Honor.
Do you agree with the state that to find that this statute acts retrospectively in the fashion that you're asking for us, that there needs to be clear and unequivocal language in the statute to support that?
I believe that, Heedlin is controlling. I don't think there's a disagreement about that. It gives us the three-prong test that would be applied in this case. I think the disagreement is what does express intent or express language mean? And we would argue that it's not the magic words of retroactive or retrospective, but rather clear intent from the words within the statute that it be applied retrospectively.
What about the language in Section 3, subsection 1 and subsection 2, the operative sections? And when the legislature passed the law in 2022, it says a person shall not engage in a practice or act. A healthcare professional or a health facility shall not knowingly, intentionally do any of the following. That shall language makes it sound like it's on a going forward basis. This is not something from now on that people should do.
And I guess we would argue, Your Honor, that the retrospective language is there is no statute of limitations. The action may be commenced at any time, and it provides a remedy for children of patients who are deceased or who cannot bring the action themselves, which when you look at the statutory interpretation, when we apply the rules that this court has laid forth for us, you look at the totality of the statute, you look at the circumstances, you look at the language, but when you look at it all together in light of when this statute came to be, this is 6 years into the sort of legal movement of we need to address this circumstance, and the circumstance that they're addressing is past abuse of fertility patients.
Isn't that a huge leap for you to say that? I mean, if I remember right, doesn't the record show we don't know what mom and dad knew? We don't know what the doctor said. I have a family member who dealt with infertility, and I believe she would have walked through fire to have a child. How do you know that it was abusive?
And Your Honor, you're correct. I mean, we went to great lengths to determine specifically what was contained in the records. There are none. We were told by the state that they were destroyed in the flood. We went to the archives. All we have is what was passed down basically to the children of Bert and Donna Miller which was that Bert was their father. And from that, we take that, like many people in the 1950s, not now, in the 50s, these procedures were predominantly to help with insemination of the husband's sperm.
And I have lots of situations I can remember where there was a ruse with the children, and they intentionally told them, yeah, he's your dad. I mean, that's not a far stretch either, is it, that the parents may have said that, but that doesn't necessarily imply that they knew it was fact.
A way to know that without the records from the university, which are unavailable.
About how do you prove abuse, you're saying, for the abusive behavior.
I think what we're saying is, when you view this in the light most favorable to the appellant, in this circumstance and under the Act, there's nothing, there's no document the state can show, or no record that says, you know, Donna Miller agreed to be inseminated by Dr. Randall. And in fact, there are, at least as far as we know, pods of his children. There's not a way, without evidence from the state itself, which they say is destroyed, to prove specifically what occurred.
Absence of a statute of limitations indicate that the statute is meant to be applied retrospectively. Wouldn't that also apply prospectively as well?
In theory, yes. But when you take it with the other two sections of the statute, when we look at them all together, the action may be commenced at any time, and giving the child the right to pursue action when a parent is deceased in light of when these services occurred, right? So if you think about it, so if it were prospective only, this statute would sit idle, potentially, for 20 years, because these children would grow up. But think about the circumstance here. These children were in their 60s when they discovered that that their father, that they knew, was not their biological father. And today, contemporary fertility medicine, it's not likely to come up in the way it has in the 50s, 60s, and 70s, because now, for example, sperm samples have barcoding. There are enhanced procedures. So much like the law, the fertility community recognized what occurred in these cases that are now infamous and changed the way that they did things, just like these statutes were intending to change.
The legislature wanted to have this statute apply retroactively. Why didn't they just say so, as they have in other statutes where they have an express retroactivity provision, like the COVID back to business law and others?
Question. None of us would be here tonight had they done that. But what I would say is, Your Honor, much like the Bainbridge and the Shell Oil case that this court decided, those were two statutes. Now, granted, they were not substantive laws like this, but that's not why we cited them in our materials. We cited them for the fact that this court found that they applied retroactively, despite the fact that what I call the magic words did not appear. They did not mention retroactivity or retrospectivity. And so I think what we're arguing is that when you look at the statute as a whole and the circumstances and the purpose for the statute, the intent is clear that it should be retroactive.
Undermine your reliance on those prior cases. It seems to me that NAHAS returned to a more code-based interpretation of how we determine what's retroactive and what's not, whereas the older cases kind of use this remedial substantive distinction. Are they even good law anymore?
Agreed that it changed, but without overruling them. So I think that, again, I don't, and even in Headland, which quoted Landgraf from the U.S. Supreme Court, the U.S. Supreme Court said when we're conducting statutory interpretation, it's not simple or mechanical process, right? We're not simply searching for words within. We're looking at the greater weight of the statute, the circumstances, and the purpose.
Nature specifically tells us otherwise in section 4.5, says that a statute is presumed prospective unless expressly made retrospective. So the legislature's passed a law to signal to the courts, here's how you decide this issue, and it's their rule that the language has to be express. I think everything else is kind of judicial gloss, right?
Agree that that's what the statute says, but is it not a rebuttable presumption? It's a presumption and I agree, that is the state of the law. We presume that a statute is prospective, but it's rebuttable based on the language of the statute, the circumstances under which it was brought forward, and its purpose. And if FARA is not applied retrospectively, the purpose is essentially defeated, because the people that it's intended to provide a remedy to have none. And it also sort of renders the provisions of that there's no statute of limitations and an action may be commenced at any time, essentially as redundant or irrelevant.
Thank you.
May it please the court, counsel. My name is Eric Wessan, representing the state of Iowa. There is one issue facing the court today, and that is whether a law enacted in 2022 that created a new cause of action and imposed new substantive obligations on doctors and medical facilities should be applied retroactively to actions and omissions in the 1950s.
It sounds like they opened the door wide open. They say, oh, by the way, no statute of limitations on this. Woo woo. So help me understand. I think that's an argument that the plaintiffs are making, is that has to mean something too. Help me understand how that's different.
Yes, Your Honor. I think the most helpful place to look is actually what you identified in the appellant's argument, which is the same commence at any time language that may be used in both the criminal section codified in 8022E as well as in 714I. And the reason for that is, as my friend on the other side said, it would be unusual within one enactment, Senate File 529, to use commence at any time in two different parts of the code to mean two different things, especially given that, as I think we all agree, retrospective application of a criminal statute violates both the U.S. Constitution's ex post facto clause and Article 1, Section 21.
Well, concedes that. So we'd have to almost have like a bifurcated position if we were to go with the plaintiffs. Do you know of any other statute that has criminal and civil remedies, well, criminal punishment and civil remedies, that one is prospective, one is retrospective?
I'm not familiar with such a law, and I think this actually gets at the heart of what Headland was trying to establish in its three-part test. So again, there's a lot of agreement in this case, and there's a pretty narrow ground of disagreement. We agree that this is a retrospective application. Headland itself said that that first step, determining whether applying a law to a given circumstance is retrospective, is often the most difficult part of the endeavor. And then you go to step two, which asks whether a law should be retrospective. The key consideration in that analysis goes to Iowa Code Section 4.5, and that is where both Nahas and where Headland explained that, and I think Nahas actually explicitly emphasized this, it's italicized in the opinion, express language of the text. And so when we're looking at the text itself, I think it's really important to use the language that this court has used going back over 100 years in Davis against Jones or Burke v. Barron, that it's almost like a clear statement rule to try to say that a law is retrospective. Here, there's no evidence other than looking at a section here and a section there and maybe trying to ascertain that if you put them together, there's an implication of retroactivity.
Argued that the fact that the provision says there's no statute of limitations and the action can commence at any time mean two different things. Otherwise, if an action commencing at any time just refers to the fact that there's no statute of limitations that makes that ambiguous or superfluous. You didn't really address that in your brief. So can you address why that doesn't mean an action at any time, irrespective of when the conduct occurred?
First, I would say the commence at any time language is the specific language that's common to both the civil and criminal provision. So I think that weighs against finding it retrospective. When it comes to the superfluity argument, the best answer, I think, is that the lack of statute of limitations says someone could sue for time immemorial. The commence at any time gets at when a lawsuit can be filed, which is from the time of enactment. Because of the unique way in which it creates a cause of action that could be brought by children involving death or other aspects of what could lead there, the commence at any time could helpfully color that you don't need to wait for a death to bring a claim. You don't need to wait for the child, or you don't need to deal with some of the different circumstances that may otherwise lead to an undue delay. From any
Explanation. I mean, it sort of sounds like the legislature intended, they may not have succeeded, but they intended to be able to reach past conduct such as Dr. Randall's, don't you think?
I don't think that the legislature intended to reach past conduct, and there's a lot of evidence to the extent that we're past looking for express retroactivity language, and by that I don't mean magic words. It doesn't need to be like, as the legislature sometimes does, a retroactivity provision. Sometimes in the Shell Oil case, for example, they said past or existing harms. There are different ways without using the word retroactive to indicate retroactivity. But if we're looking at the whole statute,
Point, what does expressly mean? I mean, have we gotten our prior cases wrong? Should we expressly require those words?
Your Honor, that would be straightforward. I don't think expressly requires the word retroactively. One example could be looking at Headland itself. I believe that there was, it allowed for the law to be applied back to January 1st of that year. But there are many cases that this court has that go back quite some time that use words like a strict construction against a retrospective application. Courts will give statutes a prospective effect only unless the language is so clear as to not have any doubt. Those cases are still good law too. I think Headland did a really nice job of trying to fit different cases into its three-step framework. And one way that it did that was it explained that a lot of the past retroactivity cases were not necessarily retroactivity cases as we think of them today. One other helpful precedent for that is actually the Dindinger case that this court came out with in 2015. That recharacterized both the Bainbridge and Shell Oil case away from the sort of generalized, the text is loose approach that predated Headland and Nahas, and instead explained how in the Bainbridge case, the application of the law was prospective, and in the Shell Oil case, you had that past or existing harms language. So here, you don't have anything like that. And to get back to your question, Justice Mansfield, about what did the legislature intend, there are serious consequences that follow from a violation of this law. Putting aside the criminal consequences, in the civil part of the law, there are penalties, including licensure, including all sorts of collateral consequences on the facilities that violated the law. Holding a health facility in the 1950s accountable for failing to get a waiver or informed consent as required by a law enacted in 2022 would create some odd circumstances. The first time informed consent and
Unconstitutional to do that. Would it violate the defendant's due process to, after the fact, impose these substantial penalties and liabilities?
That's a very difficult question that is outside of the scope of this appeal, because that gets to the third prong of the Headland test. And while my friends on the other side did brief that, it was not addressed deeply in the district court, and it was not addressed in our brief. But you don't need to get to the third step as to whether there is some constitutional stop to this type of retrospective application if you find that there's no express language.
And couldn't we, I mean, there's sort of this assumption that the language, notwithstanding any provision of the law to the contrary, an action brought pursuant to this section is not subject to a statute of limitations and may be commenced at any time, that applies to criminal and civil. But first of all, it strikes me that if it would be really a difficult thing if you had a criminal law that had no statute of limitations. And secondly, normally I don't refer to a criminal case as an action being brought. That isn't how, if I was writing a criminal case opinion, that isn't how I would describe it. So maybe that language is just limited to civil cases.
Language is, but the enactment, the Senate File 529, imposed both civil and criminal penalties. And in the same enactment, Iowa Code Section 802.2E actually explicitly puts in place a criminal, an indictment or information may be commenced at any time. And so that's part of the same enactment. So I agree that the section you refer to is civil only, but the Senate passed one law that imposed separately civil and criminal penalties and independently imposed a lack of statute of limitations on both the criminal and civil. And that's why I think looking at Headland, which did say you can look at the whole statute for textual evidence, that the evidence of a lack of statute of limitations does not cut in my friend's favor.
Could you respond to the sort of practical problem that's raised by opposing counsel in terms of, does the statute sort of become surplusage because we have this bubble of victims who have discovered their status due to the DNA testing right now, but the procedures are much tighter now, and so we shouldn't expect more criminality going forward. What do you make of that?
Legislature enacting a law to make a certain behavior criminal and then expecting less of that behavior going forward is a good public policy result. I understand that a lot of people wonder about what happened, and there are real serious concerns here, and I'm not trying to put any of those aside, but ultimately, the actual act or omission that is attached to liability or criminal liability is failure to get written consent, and that was created in 2022. The informed consent aspect of medical malpractice law in Iowa was first introduced to the code in 1975, and the doctor at issue here died in 1959. It seems a little anachronistic to hold a doctor accountable for not yet complying with future standard of care, which I'll say, I think the current standard of care is better with regards to informed and written consent than what I understand to be the case in the 1950s. And I would hope that over 70 years, there have been improvements both in the treatment and care for the patients, as well as for holding individuals responsible for actions that they took that violate that law. But that is not enough to say that we need to apply this law retrospectively. And here, I think the court has a real opportunity because Headland set forth its three-part test. I know already that you've had opportunities to look at the first step and determine whether you've got a prospective or retrospective application. One of the cases that my office argued and lost, or won but lost on this retroactivity issue, is the In Re NS case, which determined when a law is being applied prospectively to the locus of facts. Here, the court is presented with an opportunity to deal with Headland Step 2 and to really go back to what I believe is the heart of the Headland, Nahas, Herbeck test, which is getting back to Iowa Code Section 4.5 and to explain what express language means and requires. This court should find that, consistent with more than 100 years of its own precedents, that requirement is meaningful, and that the legislature, which is one of the finest in the country, is fully capable of introducing retrospective language and to make clear that certain aspects of the law like this could be retroactively applied.
In analyzing step 2, how do we interpret this statute? Does the wording used apply retroactively? Should we consider the constitutional avoidance doctrine? Because if we apply it back in time, that raises, at least in my mind, serious due process problems. So don't we need to consider the constitutional ramifications on step 2?
Understanding of Hedlund's test is that that is the step 3 inquiry, which is whether there is a substantial law that precludes retrospective application. And I think that this court engaged in what I would say is excellent jurisprudential hygiene in laying out a clean 3-part test. And I think it makes a lot of sense to hold to that test of, is the act retrospective? Is there express language that shows the legislative intent that this should be applied retroactively? And then only if you answer both of those 2 questions yes, do you then see if there is some substantial part of law that precludes the retrospective application.
Your opposing counsel persuades us that the language in there about no statute of limitations, bring it at any time, gets them past step 2. What's your position on step 3?
It would be most appropriate to remand on step 3 because then the state will have its opportunity to present on those issues in the district court in the first instance. If there are no further questions, thank you.
I wanted to go back to, at 757 at Headland, the court said, legislature expressly made the statute retrospective. And when we think about that, there are a number of cases from this court that we cited in our briefing materials, starting with State versus Pay. The goal of the court is to ascertain and give effect to the legislative intent. State versus Hawk, they must consider the challenge statute in its entirety. State versus McCullough, the factors to be evaluated when determining legislative intent are not only the language used, the subject matter of the statute, the object sought to be accomplished, the purposes served, the underlying policies, the remedies provided, and the consequences of various interpretations. And then finally, that no part of the statute should be redundant or irrelevant, as we've talked about. But we didn't really talk about some of the other factors. For example, the consequences of various interpretations. So if this statute is applied prospectively, then essentially, when you look at the entirety of what brought this statute to bear, that has no meaning because it was.
Isn't there an issue here with the legislature wanting to stop this moving forward too?
Agreed.
Legitimately something that they could have had in their minds as they were drafting this, not wanting to look backwards because what had happened had happened, and in this case, you know, the doctor had died. There might be difficulty with evidentiary issues. Isn't it reasonable to have this just forward-looking?
I think that is clearly part of what they intended, Your Honor. But when you look at all of the materials that we submitted, and you look at what was the temperature, what was the climate that brought this to bear, it was these past injustices. And I think when you look at the language of the statute in light of those past injustices, when you move forward, you know, Iowa's medical malpractice statute essentially gives you 6 years. 2 years from discovery was 6 years. And with today's technology, that's ample time in most situations to discover this. But in the 50s, 60s, 70s, and 80s, when these, what I would call violations of trust, right? That this is a very intimate procedure, probably the most intimate procedure that a patient can have with a physician. So when this occurred and all of these children came to discover oftentimes years after their parents had passed, that their father was not their biological father. It's not just that he's not the biological father, it's that they don't know half of their medical history.
Lorenzen, about sort of a kind of us being fair to the legislature. So in 2021, the legislature adopted qualified immunity legislation, and it basically said employees of the state aren't going to be liable unless for damages unless the law was clearly established at the time of their conduct. And we said, hey, you know, in the Carver-Kim case, that's got to be applied prospectively, not retrospectively. I mean, it would really be kind of unfair to apply that, go back and apply that backwards, be unfair to plaintiffs. Now we have in 2022 a law that says, all right, you can sue at any time over a cause of action that is a new cause of action. Wouldn't it be, you know, kind of unfair to say that the immunity is prospective, but this new law is retrospective? That seems like we're kind of, you know, kind of whipsawing the legislature if we do that, aren't we?
Your Honor, I think that in Headland itself, the court cited Landgraf from the U.S. Supreme Court, and the quotation in the decision was that requiring clear intent assures Congress itself has affirmatively considered the potential unfairness of retroactive application and determined that that is an acceptable price to pay for the countervailing benefits. And so I think it's always unfair to one side or the other to apply a law retrospectively. But in this case, in light of the facts and circumstances that brought this statute forward and the language, the express language of the statute, I think that there's clear intent that they did consider that, and they felt that the retroactive application outweighed the potential injustice.
The constitutional obstacle to imposing new liability after the fact and reviving a cause of action that presumably would have been time barred, at least under the Med-Mal statute of repose.
The bigger constitutional challenge, in my opinion, is to the criminal aspects of the case. Obviously, there's ex post facto considerations. I think, you know, this was briefed, I would say, lightly at the district court level, and predominantly it related to issues of the availability of evidence and how would we establish this. And at this point, that's unknown, right? Because we didn't go down that path. We had a single deposition. The ability to track down additional patients may serve as, provide the ability to clear up things that we don't know now. And so I think remand is probably, I agree with the appellee that remand is probably the appropriate action to take on prong 3 because we don't know as to the civil action. I don't believe that it's a bright line the way that ex post facto operates on the criminal side.
What evidence do you think is needed by either side to address whether it be unconstitutional to apply this statute retroactively?
Well, I think that the constitutionality of it, in terms of it, in this case, we're talking about a purely civil remedy, not a quasi-criminal, like in some cases where civil actions run afoul of due process is where there's a quasi-criminal penalty, like the loss of your license or other actions like that. In this case, it's a purely civil.
$1,000 penalty for if the parent victim is still alive, $5,000 for the child. So there's a little bit of that.
So it's a penalty, but I think part of this, when you look at it, and you, Justice Moderman, you talked about the medical malpractice statute, but there have been times that this court has found that the statute in and of itself didn't provide justice. And what I would propose to the court is, if FARA is not to be applied retrospectively, then the justice that it seeks to provide, the largest population of victims will be will be provided no relief. And so I think you have to weigh the cost and the benefit, and I think the legislature did that, and that is why the language that they used points to retrospective application.
Question for you. If the language, this section is not subject to a statute of limitations, was not in there at all, would we even be here today?
I think it would be a much more difficult argument, Your Honor. And I don't think that you can look at any one of the three parts of the statute that we point to, whether it's the no statute of limitations, an action can be commenced at any time, or the provision of allowing a child to bring an action for services that were provided to a patient or a parent, decades earlier. You have to look at all three. Thank you. Thank you.
Miller versus State of Iowa is hereby submitted. I did not do a very good job of finding out from the people who know way more than I do exact details, but I do know we're planning on meeting anyone who's available down in our light court, which is on floor 2. There's a stairwell or a couple elevators you can take to floor 2. Go through those doors, and it's called the light court. It feels like you're outside, but you're not. And I would like to say we're having milk and cookies, but I highly doubt the milk, and I'm not even sure about the cookies. But there should be something, perhaps water and saltines, I'm not sure. We are a branch of government, so anyway. But we would welcome you to join us. Give us about 5 minutes to take our robes and hang them up, and we would like to join you. So with nothing further, court is adjourned.